All right, people I think are still logging on, but I'm going to go ahead and get us kicked off. My name is Lucas Peralta. I'm an associate director at the Polsky Center for Entrepreneurship and Innovation here at the University of Chicago, and we're excited to have you for one of our Entrepreneurship Essentials series, Legal Issues for Startups. I'm excited to introduce our presenter today, Heather Harper. Heather Harper is a longtime friend of the Polsky Center, and she has been working in our mentorship program and working with some of our NVC at College New Venture Challenge teams for a while. And so I'm excited for you to meet Heather and to learn about some of the key legal issues that founders face when they are starting startups. So Heather, would you like to just give your introduction and give a little background about yourself?
Sure, absolutely. Hi, everyone. So as Lucas mentioned, Heather Harper. I wear a lot of hats. Right now I'm sitting in front of my window hat, so I don't have a fake background. You see a bird, that's where we are. I'm a professor at IIT Chicago-Kent, and I run a startup clinic there that I call the Startup Legal Shop. So some of you might have heard that. I also run a private practice called Harper Legal with just a lot of the attorneys that several of them were former students representing startups and growth stage businesses. And so today's presentation, what we're trying to do is cover a lot of just like an overview of where things are. I was taking a look and speaking with Lucas about this, and I realized all of you have your cameras off, literally 100% of you. And all of you are on mute, which I think is probably part of that. Okay, so how about you, how you came in? So we can kind of do this however we want to. We have an hour. The way that this session is supposed to work is like, it's a lunch. So you see me and I kind of walk around the room and you guys get to eat. I hope some of you are eating now. I'm not going to eat while I give this presentation. And it's really meant to be dynamic and interactive. Like, I know some of you have questions, so we want to answer those questions. This is a big group. I want to encourage you to use the chat. So as I go, anytime you want to use something in the chat, I'll stop and I'll answer the question, maybe not at that moment because there are lots of different screens. And I don't know where you guys are in the world or what you're interested in. And since there are so many of you, we don't really have an opportunity to kind of stop and ask all of you, which I would if you were in a room. But if I'm going over something, you're like, oh, we already know this, then thanks, just say, we're really more interested about boom, 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 and I'll switch it, okay? We're use this thumbs up. You can also use the thumbs up on Zoom. I do like feedback. It makes me feel like I'm not talking to an empty group of people. This is getting recorded, which I said, spoke with Lucas about, I think it's helpful for people. So you can take a look at it after the fact. But if it is becoming distracting to being part of engaged in the conversation, I can understand that as well. Just feel free to like, let me know or send that over or to Lucas and we can figure that out, okay? All right, here we go. I have a slide deck that students put together for me a while ago. I'm gonna use it, I think, unless we're like, boo, this stinks, let's just see your face, because sometimes people are visual learners and sometimes people are auditory learners. But we're really gonna go over today kind of like some of the main, all right, let's see here, from the beginning. I'm gonna screen share. Oh, you disabled screen sharing, Lucas.
Sorry, I need to make you host.
No slides for you. Oh, it's okay. No slides for anybody. No slides, no suit, no nothing.
There you go.
Right. There I am. I'm gonna try to admit people as we go too. All right, here we go. Actually, okay, so here we are. So without going into all of them, because I don't have an overview, I've got about 7 topics that I want to cover today. Entity selection, founders agreements, IP, financing, labor and employment contracts, and working with a lawyer. Now, I got to tell you, I teach a class in entrepreneurship law that roughly goes over those topics, and it is a 4-credit class that goes all semester long. So I'm going to be talking real fast. You can take notes really quickly, okay? And in addition to that, if you're like, hey, we're not really interested in this, move on, then let me know. I actually think that, all right, entity selection. I'm gonna make all of these go. This one's gonna go quickly. How many of you here, and I'm gonna try to see you so that I can, where are you guys? How many of you have already started a business or are essentially have already formed a business. You could let me know in the chat, like yes, no, just quickly. Someone's got an LLC. Someone's got an S corp. LLC. Anyone? No. Okay, we got one no. Nope, not yet. All right, thanks guys. So generally the first question that you would mainly have is like, when do I start an entity? What kind of entity do I have? I like to tell people the triggers for starting a company are you've moved past the stage where you're just thinking about an idea and you're now at a place where you're working with others, developing IP, talking about equity before having a financing. You're going to have customers, and you really do need to actually, like at this point, kind of have something that protects your legal liability. What this doesn't do is it's not something you want to start when you're really just like in a class, you're an idea, or you're not sure if you want to continue. Because once you start a company, there's filing fees and all sorts of other things. And really it's, you know, sometimes we're just thinking about whether we start a company. There are three main choices to starting a company for a startup. Now there are tons more in the world, but I've found that we can distill it down to really three in this world: the C Corp, the LLC, and the S Corp. I have a really quick way to look at this, right? The first is corporations are just, they're entities formed in states, Illinois, Delaware, wherever. C Corp is your default corporation. S Corp is an election you make. I'm gonna knock that one off. Does anyone here have an S Corp that they wanna tell me why they have an S Corp? Quick chance. If you do, put it in the chat. If you don't, I'm gonna just tell you the answer. All right, we got some chats. Social, taxes, tax purposes. Yes, tax credits. Okay, we've got it that it's a tax purpose. People, the type of companies that work really well for S Corps are service-based businesses, like law firms, consulting businesses, photography businesses, businesses that don't have a lot of capital needs. They don't generally need investors. And for whatever reason, they're gonna pay a lot of money to the founders or to the owners right away. The reason for that is because number one, it's corporation. And so it has, like, as an S corporation, it has flow through taxation, meaning you don't pay that once at the corporate level like Pepsi and once at the shareholder level like Heather owns Pepsi. I don't actually own Pepsi. I don't think. I might in a mutual fund somewhere. So you only pay taxes once, it's flow through. The other reason you use an S Corp is because there are sort of tax benefits to it where you can reduce your self-employment tax if you pay yourself a reasonable salary. So for instance, my law firm is an S Corp. And so I pay myself as a lawyer a salary under that, and whatever profit I might make that is over and above that, that's a distribution to me as an owner, and it's not attributable directly to my let's go back one. It's not attributable directly to my work, which would have self-employment tax to it. So that's one of the reasons that you do an S Corp. There are a lot of limitations of S Corps, and I'm going a lot of screens. So if I'm missing your chats, let me know. There are a lot of limitations on S Corps. Most notably, you can't have more than 100 shareholders. It has to be owned by US citizens and permanent residents. You can't have multiple classes of stock. So that means that if you're gonna be a person who needs investors, who thinks you're gonna work with a broad group of people or with, again, investors who are investing in entities and such, an S Corp is not a good structure for you. The S Corp is good for your general, operational, service-based business. Got it? All right, looking at the chat. Slides are not changing. I'm not changing the slides yet because I think it's too many. So this is one slide. I'm going through all three of them. I accidentally did it. Got it. Okay. The LLC and the C Corp. So an LLC is your general default one for I'm running a business, I'm working with the business, and I don't think I need necessarily investment, but I don't know, and I don't want to pay double taxes. So I think about this like a restaurant, a cabinetry-based business, something where you may need investors, but you may make money. The question of whether or not to be an LLC is when you're initially putting together your business, do you, when you're initially putting together your business, do you think that you're going to lose a lot of money so that you could take advantage of tax losses while you kind of bootstrap and get going? Or do you think you're going to make a lot of money before you actually need an investor, or you never need an investor? If the answer to those questions is Yeah, I'm going to lose a lot of money and I can take the tax advantages. Or, yeah, I'm going to make money and I don't want to pay double taxes. Then an LLC is a pretty good place to start. A C Corp. Okay, hold on one second. I've got a lot of really good questions. Oh, you're all participating. If a company starts as an S Corp, can it be changed to a C Corp and an LLC? So we'll talk about the changing of the entities right before the other ones, okay? C Corp. The C Corp is in my opinion, that's sort of the example of the good business. So it has the big business, not a good business. All of them are good businesses. The best business is one that makes money. So anyway, you have a C Corp, like any large company where you have the board of directors and they're the ones who run the day-to-day operation. Then the shareholders or the owners are the ones that really don't have anything to do with the operation of the business, but they're the financing source for the business. That makes a lot of sense in larger companies. It makes some sense in smaller companies, but for our world, like the startup world, that makes the most sense when you are going to be in a high growth area and you think that you're going to get venture funding. Now, what I mean by think you're going to get, I mean, you should be relatively sure about it because we're going to talk about the distinction between going from one to the other. But the standard venture deal does generally still favor the C Corp. Actually, a lot of private equity deals, which are further on and later for businesses that grew without that financing, will and do them in LLCs. So remember, these aren't absolutes. People who tell you there are absolutes are, I find that to be a little bit too binary. So in general, with entity selection, you want to be, if you're a service-based business, an S Corp. If you're a business that's not a service-based business, but you're going to lose a lot of money and put a lot of personal financing in, or you're going to make a lot of money, maybe an LLC. If you're going to go and kind of just raise money on standard VC stuff, then maybe a C Corp, right? You can go from an LLC to a C Corp. You can go from an S Corp to a C Corp. But if you go from a C Corp to an LLC or a C Corp to an S Corp, you may have some tax results that are not particularly good. Mainly, the double taxation that you're trying to avoid is triggered by the conversion from a C Corp to something else. So once you're a C Corp, you're usually a C Corp. All right, Christian says it's a B Corp, a type of C Corp. Oh, the letters, it's alphabet soup. A B Corp is a benefit corporation. It is a function of state law. And that, if as a benefit corp, you can be either taxed as a C Corp or you can be taxed as an S Corp. But a benefit corporation is one that makes an affirmative duty in its charter to say, I'm going to take care of some public benefit, and I'm going to hold myself accountable to that by some third party, usually B Corp Labs, assessment of that. Okay? Now remember, this is an overview. I give whole classes on all of these things. We're going to move on to the next one real quickly. Can I get a quick thumbs up? Can you convert from a C to an LLC before you get revenues or a tax obligation? I mean, you're still doing the exact same thing, right? Like you're converting, so you will have to pay double taxes on whatever it is. From a tax perspective, if you don't have any revenues and you don't have any assets or anything, there's really not much to pay taxes on. But in general, like, you don't want to try to go back from one to the other. Investors with international students, a lot of the times that would generally be a C Corp, but we can talk about that more in general. All right, this one I want to talk about more broadly. Whoops. So I also found that if I click on it, that actually goes to the next one. Choice of entity is easy. And what I mean by easy is I just very quickly, but like gave probably too much time for it in this presentation, gave you, here's what you should be. But like if at any given moment you're like, hey, this is confusing and I'm not sure, I can troubleshoot you your choice of entity within 5 to 10 minutes with some pretty good certainty, and like, here are your trade-offs, right? Founders agreements usually take a little bit more time to have a conversation about it. So rather than talk about all the different details you think about in founders agreements, I want to give you a framework for thinking about this. When you work with one or more people, you have a lot of risk that your expectations are not aligned. And as such, you guys are running down different paths and not necessarily following or understanding what other people are doing. All right, we have a question from the audience. I'm going to take it. Can you unmute yourself? First?
Thank you, Heather. Yeah, I put it in the chat window, but the chat window kind of goes up very quickly.
It's
There's so many
also just
great
like I'm
questions.
missing the, yeah.
There's so many great questions coming in here. But when it comes to financial services business or a fintech business where people's money will be involved and you'll be taking people's money and then investing it in capital markets, what kind of the three domain, entities should you to consider?
Well, I think it really depends. I mean, generally when you're doing, I'm not sure exactly which one you're talking about, like in terms of a fintech or finance related business. Let's say you're a fund business. So you're actually like, you are investing other people's money. You generally would be a flow through. There are a lot of sort of vestiges from the past of using limited partners for funds. But oftentimes, like in this day and age, people will use LLCs and then they'll have different, like you'll have a fund and then a manager, et cetera, et cetera. If you're a fintech company that's like running essentially a tech startup, you know, oftentimes people will be in C Corps. So I think it's pretty fact specific. All right.
I mean, I think my question was more to do with robo advisory. So let's say that what would have Robinhood started with in the beginning?
What would what?
In the very beginning, what would have Robinhood, the company, started with in the very beginning? Would they be in the beginning when they started? Do you think that they were LLC or LLP or C Corp?
What's Robin? I'm not sure if I know what Robinhood is.
Okay, I'll take it off.
Okay, but I'm happy to I'll put my contact info up on the end, and I'm happy to kind of just chat offline about any of these different things. All right, moving on to the founders agreements. Thank you for your question. So with founders agreements, anytime you're working with more than one person, you're not working alone, this is involved. And again, what you're trying to do with a founders agreement, which, like, what do you mean by a founders agreement? I mean the collection of agreements between the founders. It's usually more than one document, and it depends on what entity you select, that defines the expectations you have with respect to each other and provides consequences for failure to meet those expectations. So let me give you a for instance. I am going to start a business with Lucas, and he's got a full-time job doing all this Polsky stuff, making sure you're working. And I'm like, hey, I only am working on this exclusively. Well, you can see that actually we both have different starting points. Now let's add something kind of different. Let's say that Lucas is also a part-time MBA student, and definitely, like, it's kind of expensive and wants to finish that degree. And maybe after he finishes that degree, might want to go work for a tech startup like out in the Bay Area. You don't really know, right? Do you see that actually, like, when Lucas and I come together to make a business, we have our own individual expectations of what we're going to do and how we're going to engage with each other and like why we're being involved in this. This is especially true when you move from a university to, or any sort of like a bootstrapping university, anything that's not just like, I got hired by a business. It's really important that founders discuss those expectations. What are you going to do in terms of when you quit your job? Do you leave your schooling? Do you take no other summer jobs? What expectations do you have with respect to each other in terms of like what you're going to bring to the business? And then generally you put that into some sort of a document. And again, it depends on where it is and how it is. And I would advise working with a lawyer to do this right to avoid bad tax consequences. But you have conversations like that, and then you generally use, you put consequences in the documents for failure to meet those expectations. So the very common consequence that people, startups use is vesting. If I'm like, I'm gonna work full time for this business and to the exclusion of other businesses, I'm gonna enter into a vesting agreement with the company. Me, Heather, enter into a vesting agreement with the company. And if I quit my job with the company and I go and decide to take a lucrative job elsewhere, well, then I've basically just said I don't meet those expectations and the vesting stops. So that's a really good and easy kind of way to do that. There are also other things, like in general, founders agreements start with a vesting agreement. They also have some sort of a proprietary rights and innovation agreement or some sort of an initial agreement where you are agreeing to be confidential with whatever information. You're going to assign intellectual property to the company. That's a freestanding agreement that generally other people who work with your business will also sign or some derivation of that. And then again, depending on the type of entity you have, you'll either have typically some sort of stockholders agreement, an LLC operating agreement, or lawyers can put these in all different areas, right? But what's important is not what the name of the document is. The important part is that you have an expectation, you set consequences, and you know what happens if things go wrong. That varies depending on the business. If you're a VC-backed kind of tech business that's in a C Corp, it's actually pretty easy. And this is to Jad's point. Are there general expectations? Yeah, if you're, a tech-based growth business, it's like you're going to work full-time for the business, and here's like the standard corporate form, and you don't really have to talk about management so much because you have a board and because you have these different roles. If you're in an LLC and you're really just two people running kind of like a Mad Men version ad agency, you may have to have more conversations about how you're going to manage the business and like what different groups you're going to take in. If you take this client, are you going to take other ones? Annie asks, is there any benefit for founder solo to create a founder agreement, or simply clarify, or is it simply clarifying between founders? Good question. A founders agreement generally does refer to two people, but you do, if you're in a tech base, or if you're in like sort of the standard VC cycle, at some point you're probably going to have to subject your equity to vesting. And so it does seem a little weird and janky if it's just you running this business to enter into a vesting agreement. But if you're a corporation, you got to get your stock to you somehow, and that's probably one way to do that. You would also, at some point, if you grow, have to have a confidentiality and assignment of IP agreement. Now, Annie, if you were running like a law firm and you're the only person who runs the law firm, then again, you wouldn't need that. So the type of business really does determine what founders agreements you have and which ones are appropriate. This is one of the reasons why I think it's probably a really good idea to work with a lawyer in this section. There are lots of legal clinics around in the area, and they're really good and killer at founders agreements and having that conversation. So there are a lot of really good resources out there. But this is one where if you get it wrong, it can be really painful and expensive, because I don't think it's because you didn't talk. I don't think it's because you're like, oh, I didn't sign that document. It's actually because you never had that conversation. Let me give you a quick example. Like, I once worked with a group coming out of I'm going to abstract the details a little bit, but they were a student group coming out of a university, and they had created this product in class and knew enough in class to say, let's get some IP rights around the product, and did some sort of like a crowdsourced campaign to sort of pre-sell the product, just all again, figuring out, should I do this? But never stopped and asked the fundamental question, like, do we want to start a business together? And now I know that sounds actually silly, but guess what? They didn't. They just like didn't. They had not aligned on that. One of them was like, this is fun, this is cool. The other was like, this is a business. And they're just like not aligned. And that lack of expectation sharing, everything followed from. When one worked too much, the other one was like, but why? I'm going to go take my job. They never had that conversation. Certainly never set expectations from it. I think if they'd had that conversation, they would have acted differently, and it would have been more aligned to both of you. Because like, again, especially in working with students, yes, I'll provide some resources with the clinics at the end. When you're working, especially coming out of schools and students, like, which is really great, people have different expectations, okay? I'm going on to the next slide. And I know, I'm like, why are you showing all of them at once? Because I think it's easier. Intellectual property. Intellectual property is in every business, okay? I want to make very clear that everyone understands that. There's just like, IP is everywhere. It's like when high school chemistry teacher, chemistry is in everything. I can't tell you about stoichiometry anymore, but I can tell you about intellectual property. That's the mole bridge. Hey, that's pretty good, right? All right, anyway, there are 3 ways that I want you to kind of think about intellectual property. The first is identify the intellectual property in your business, because all of them have it, so you should identify it. The second is try to figure out how to say, all right, how do I avoid infringement or taking other people's rights and getting myself in hot water? And then the third one is, how do I protect it? If you use that rubric, you will be very well served, because then you're not kind of running down in different directions. You're sort of like 1, 2, 3. So there are 4 kinds of IP. Does anyone want to tell me them in the chat, or should I just go for them? I'll drink a little coffee here. Trademarks, yes. Copyrights, patents. Oh, what's the 4th? Trade secret. Oftentimes seen as like that. Oh yeah, we got some trade secrets. I got some trade secrets. Okay, 4. Patents, copyrights, trademark, trade secrets. Think about these 2 together. Patents and trade secrets work like opposite poles. So on the one side, a patent is a government mandated monopoly to sell something that is an invention. If you invent it, it's novel, not obvious, and useful. You can file with the US Patent and Trademark Office for a patent. They will give you certain rights based on claims. So it's not like, bless, this is a patent, right? It's not like, this is a patent. It's like all the different claims for this cup that may be patentable. And then it is an exclusive right, meaning you can stop other people from selling or using any of your patented stuff for a certain period of time, provided that, even if they independently come up with it, okay? A patent is the most formal in terms of you have to file for it. It's only for specific claims, but it's an exclusive right. It's very, very protective. That's why you'll have non-practicing entities, or otherwise known as like trolls. It's the season of trolls. I don't know if you didn't go to the Arboretum to see the trolls, like they're delightful. Anyway, you can stop people from using it even if you're not selling it yourself. On the other hand is trade secrets. Trade secrets are protected generally under state law, also federal, that says, as long as I keep something secret and there's value to it being secret, then we will, as the sort of government, protect that. So against from like corporate espionage, if you will. But what that really means is that you actually have to take reasonable steps to keep your stuff secret. Trade secrets last as long as they remain trade secrets under law. So if you think about like the secret, the Colonel Sanders, however many spices and herbs, I don't know how many there are. I have not had KFC in a while, but like all of the secret mix there, or Coke's secret recipe, or a lot of recipes and a lot of other things. Like as long as you keep it secret and there's value to it keeping secret, you can maintain that. And that's really protective. So you see how a patent is disclosure, and you get a monopoly for a period of time. A trade secret is keep it quiet, and you can keep it as long as you keep it. They're actually totally opposite, right? And your strategy of which one you have and how you're going to protect it depends upon which one you're picking, right? In the middle, we have copyright. Copyright is an expression of an idea, so it can really range. It can go from music, books, also to software code. Code is generally considered a copyright. And then you have trademark. Trademark is a source identifier. So that's going to be something where it's a brand, and the brand, so in this case, LaCroix, the brand is LaCroix. I know that in the sparkling water, the taste is going to be, mild and not too artificial. This is plain, so it has no taste. But like I like to say with Intelligentsia, I prefer their coffee because it's not burnt. It has kind of a rich flavor. Starbucks has a little bit of a burnt flavor. So you know what you're getting as a consumer based on the source identifier. All right, let's see if we got a couple of questions. Pictures, copyrights. Yes, pictures are generally copyrights. I've incorporated and studied trademark issues. DBAs are different from trademarks because DBAs are actually like their corporate entity name. So let's say that I have something, Harper Legal is a good example. The name of my law firm is Harper Law, LLC. I call it Harper Legal. That's a DBA. It's just a name that I'm taking for my entity. If you want to do trademark protection, that's different and separate from the name of your business. Let's see if we have any other ones real quick here. Why is IP discouraged in the software development? Do you remember? Well, that's really interesting, Chad. So I'm going to actually say it's not, but I think what you're saying is why are patents sometimes looked down on in software development? And it really depends on who you ask. I think you should definitely ask a patent lawyer as soon as possible, because with patents, you have a year in the US from the date of first disclosure to protect your invention. That's called the statutory bar. If you go past that, then you've lost rights in that. Because remember, it's it's a disclosure in exchange for a monopoly. So if you've already given away the secret sauce, like why would the government want to give you a monopoly, right? So there has to be some secrecy there, some novelty there. And so you should ask about it in the beginning. One of the reasons in general people dislike software patents is because the claims are really soft and gushy. So on the one hand, there's a lot of litigation over software patents. On the other hand, if you're trying to build your portfolio on it, sometimes you can very easily design around software patents, but there definitely are people who say like, I need and want a software patent. So like reasonable people differ on that one. All right. How do lawyers help with websites, domain name squatters? Are these, so cyber squatting is a separate thing and it relates with trademark usage. I would say get your, but the way that happens is like you own essentially a trademark and someone else just holds it and sits on it while you have like a regular and general use for that. A lot of the times with startups, we do it the opposite, which is we'll go through and say, okay, pick your name, make sure you have a good trademark, and this leads us into avoiding infringement and protecting your IP, okay? With avoiding infringement, let's start with trademark. In order to, you infringe on someone's trademark if you use a mark that is confusingly similar to someone else's. So if I'm like La Croxer for water, that might be like too close. Or if you guys have ever seen Coming to America, can I get a quick, how many have seen Coming to America? Put your hands up on Zoom. Okay, we got Michael, he's in there. We got Lucas, we got some people, Annie's seen it. Okay, good. So Coming to America, if you've not seen it, I strongly recommend it. It is a very good movie from like a long time ago. There might be some things that don't hit, right? There definitely are some things that just don't land in 2020, but one of them is trademark infringement. So the owner of McDowell's has a restaurant and it looks just like McDonald's. And at one point he goes through and he says, see, they have the golden arcs. Or they have the golden arches. I have the golden arcs. They have a sesame seed bun. Mine, no sesame seeds. And he goes through and he draws all of these tiny distinctions between McDonald's and McDowell's. And at one point, spoiler alert, he's looking through the McDonald's like manual, like because the joke is he's got like sort of an infringing restaurant for McDonald's, right? And no, Coming to America is not recent. I think it's like the 80s or 90s, very, very long time ago. It's a very old movie. It's like Trading Places, old. These are old movies from Eddie Murphy, like way back before he played lots of kids movies. Anyway, so that's that's trademark infringement. When you are essentially drafting off of someone's goodwill and you create something that is confusingly similar to someone else's. So how do you avoid infringement? Easy enough. You avoid infringement by doing a trademark search on your mark and seeing, are there any people or companies using a mark in a confusingly similar way? Now, that's not the same as using the exact same name. It's confusingly similar. Think about McDowell's. It's not McDonald's. It was close. It wasn't meant to be exactly the same. It was meant to make you think of it, but confuse you. That's the infringement threshold that you're trying to avoid, confusingly similar. Now, there are infringement thresholds where if someone has a famous mark, it cannot be confusing at all, but if it dilutes their mark, you're going to have an issue, which is why like Starbucks and such are just discouraged and could be bad. But that's the first part with trademark. How do you avoid IP infringement with patents? Well, sometimes you kind of don't. And that's one of the reasons people are a little like, oh, it's not necessarily, if you have like high technology, you definitely want to do a freedom to operate search. But I think it's a fair point to say that like a lot of the times you're not going to do freedom to operate searches for just like your regular everyday business on a patent, because there are so many patents and so many potential claims out there. And a lot of them, especially in the software area, are really broad, but that risk is kind of always out there. And that's one where if you haven't heard of sort of like non-practicing entities, that's kind of a separate one. Avoiding infringement with copyright's relatively easy. So somebody asked, now we're just like really into this movie. I love it. I've never seen somebody feel just cha. Avoiding infringement on copyrights are relatively easy, but believe it or not, sometimes people still easily mess it up. So someone asked about earlier on a photo. You can't go to Google and pull down a photo and like drop it on your website or anything like that because you don't own it. And then there's like subtle ways. So actually, like when you're putting something to print, you actually have to make sure you own the font. You have to make sure that you own all of the underlying visual properties to something. One of the ways of avoiding copyright infringement, the easiest way for a startup, is ensure that the people you're working with don't have other intellectual property assignments with different companies. So if your CTO also has a day job being a CTO at another company, it's entirely likely that that person has infringed or has assigned her intellectual property to her employer and can't assign it to you, and your use of it may constitute infringement. Okay. And then in terms of trade secrets, again, that one is pretty simple. It's like, don't take trade secrets, right? I mean, don't take trade secrets. But believe it or not, even though that seems obvious, when people leave employment to go to another employer, a lot of the times they're like, oh, but I did this at my current employer. And they sometimes like, I don't know what the word is. You'll see it. It happens more than not. So when you run a business, if you're bringing somebody over from sales, okay, or you're bringing someone, you want to make sure that the person you're bringing over doesn't kind of pull their customer list with them, because in that point, you might get sued for unfair business practices. In terms of protecting your IP, once you sort of identified what it is, then you can take reasonable steps to protect it. And again, all of you will have it. All of you will have something, either a trademark or a copyright, potentially a patent, maybe trade secrets. You protect a patent by protecting novelty and then filing. You protect a trademark by using the trademark in commerce and then by filing. You protect a copyright by putting something in a tangible medium. You don't have to file for a copyright. Before you file suit, you have to file for a copyright if you're going to sue about that, but not everybody. And one very important way to protect a copyright is make sure everyone who's making stuff that's copyrightable, like your blogger, your social media person, your developers, all those people that are making all that content, they've assigned the intellectual property to your company. That's a good way to protect your IP there. And then with trade secrets, you protect that intellectual property by, one, ensuring it stays secret. So making sure everyone has a confidentiality agreement in place and ensuring that you're taking reasonable steps to limit disclosure, because once it's out, it's out. So going back to kind of our founders agreement thing, one of the founders agreements, and it's not really a founders agreement because Annie asked this question, well, do I do it alone? Is the proprietary rights and innovation agreement. That is essential to the company protecting intellectual property, right? Because it identifies all the different ways and it says, okay, Heather, Lucas, independently, you guys create IP. We don't want you to own it independently. We want the company to own it. So you're going to assign that to the company. You're going to stay confident. That's going to be confidential information of the companies, et cetera, et cetera. Okay. What's the rough estimate to set up, say, an LLC and file a patent? Setting up an LLC is very cheap. Depends on if you do it in Delaware or in Illinois, but like we're talking hundreds, not thousands of dollars. If there's the main legal spend there would generally be on founders agreements if you had to have one. Filing a patent, I'm not a patent lawyer. So like, you should talk to a patent lawyer, but there really are ranges there. I mean, you can have people who are getting you a tight, expensive patent. You can have like essentially a really cheap patent. I used to live on the block with a lot of patent lawyers that always said I could patent a bologna sandwich, which I think means, you know, you don't always get what you pay for. There's not like a $1 amount. Okay. All right. Let me see. I'm looking down. I wrote this. I'm actually nailing through these topics. I mean, the chat's distracting. I love it. But it was hard to talk and see that coming to America. Or no, not coming to America. We were talking to, yeah, that was it. On the same chat, because I just wanted to jump in on that conversation. All right. So we're going to talk about financing quickly. Now, financing is important because I should ask, what's the, well, it's maybe not the easiest type of financing. What's the oldest type of financing that exists? In the chat. Bootstrapping! Woo! Maya, you got it right off. Yes, make money. Make some money, okay? So I want to be really clear, friends and family. Thank you, June. These are all true things. One financing is a way to get money if you need startup capital. But one way to do it also is just to bootstrap. So save some money, wait, and then as you're going, like you kind of use your funds to grow your funds or to grow your business. That is, I point that out because there's not a lot of legal aspect to that, right? Like that's not on the slide at all, but it's there, and so we want to kind of point that out. In terms of options, there's really like two big main groups and then subgroups. You've got convertible stuff and you've got equity stuff. There's debt too, but debt is oftentimes either convertible debt or it's something that's a little bit further along. It's not generally, getting a bank loan is not generally available to most kind of startups. There are some small business loans out there. And then there are some other exotics like Kickstarters and such. The convertibles are a really good way for you to very easily and cheaply pull on money when you don't know the value of your company. So SAFEs, which are simple agreements for future equity, and convertible notes, which are a little bit out of fashion, at least in my practice. They're still used for sure by some investors who want to do a convertible with like more protections, but let's just for now kind of clump them together. A SAFE is not debt. A convertible note is debt. And so, but what they do is they try to say, I'm going to put this money in the business and I'm going to just like allow the valuation of the business to be kicked down the road a little bit. And I'm going to let all of the special rights that we talk about in the price rounds also be determined later. That's very beneficial for the company because in the very early stages, if you've ever seen kind of Shark Tank, you know, your company is not worth as much. It's just not. So if you need that money in the early stages, somebody's going to give you a price round, they're going to own more of your business than if they price it later. The second reason is, if anyone has ever been through sort of a price round or seen a term sheet, and this was where if I could switch screens fast enough and get this done in 15 minutes, I would show you. Like the NVCA, which is the National Venture Capital Association term sheet, is a great learning experience. It's super long. It has got a ton of legal terms in it. Well, if, you know, June points out that early financing is like your friends and family. Those are people who are not looking to get a return. They're looking to like support you. And they don't maybe need to be the ones that are asking you whether or not you want a, you know, 2x liquidation preference or you want a participating liquidation preference, because that's not, you know, they're not looking for those kind of terms. Wait later for some of the VCs to come in and negotiate those terms. So SAFEs and convertible notes can be used easily and quickly. One of the risks of them is sometimes it's really hard to like fully understand as a founder how much dilution you're getting by just like, you're sort of like continuing to write the check and they don't really cash the check until the end of it. They've made a post-money safe that makes that somehow better, although we can't talk about that at this point. There's still like some complexity in figuring out exactly how much of the business you're selling in the early stage. Okay, Sebastian, how do we define the company's convertible note valuation cap if we don't want to value the company? This is getting a little bit detailed, but I like it. There are two ways that you pay someone, and it could be one or it could be either. It really depends on the commercial terms of the note or the safe. But let's say that Lucas invests in my company on day one. I might give him a cap, a discount, or both. A discount is, okay, you give me $100,000, and then when I eventually sell equity to somebody, I'm going to give you 20% better price than I gave the other people. So you get a 20% discount. Well, that's a pretty good deal if the value of stock doesn't go up very much. It's like, you know, it's not bad. But if the value of the stock goes up by, let's say, 10 times, then Lucas had a really bad deal, right? The cap protects that. So it's not technically a valuation. It is a cap on valuation saying, okay, fine. So let's say it's not $1 million that you're actually valued, because we don't know, right? We're all acknowledging we don't know. It's not $10 million, but let's set that cap at $3 to $5 million. I'm gonna set the cap at $5 million so that if you do get a $10 million valuation, I'm gonna use the $5 million one so I get more stock. It's a cap that protects the investors. Now, how you pick those numbers, they're market terms. So it depends on how hot your company is, where your location is, and what your investors expect. There's not really a lot of like actual statistics or value behind that, because again, what we're trying to do is protect against runaway valuation. All right, price rounds are the opposite. Price rounds happen typically in this market after you've been through a little bit of some convertibles. And in this case, you can either have a price round where it's like a series seed, and I mean that by on the series seed documents is generally the company will put together a term sheet and shop it to a lot of investors. Or you can have an investor come to you with a term sheet, which is a lot of people's sort of goals, especially out of things. And those are typically on the National Venture Capital Association, NVCA, which is in the chat, paper. And so again, they're relatively like predictable. There's, you know, whole classes on them where they talk about, here are the general business terms. I mean, at some point, if someone's interested in hearing about like terms of preferred stock, we can always do a conversation on that. Price rounds generally they're good when you get to them, but they require more negotiation. You give up more rights. And so they're not oftentimes the best starting off point if you're in the friends and family mode and you can take on money in an easier, cheaper way. Debt is something that usually happens much later. So either you're in a smaller business, like you have an SBA loan, or you're having real estate or something, which is common, or you have a non-dilutive financing source, like you're in a scientific area and you get a grant, which is not a loan, it's a grant. Or you have a Kickstarter where you're pre-selling your stuff. Traditional debt is usually for startups once they're past a few stages, and usually is like a line of credit or something beyond that, because banks are conservative financing sources. With financing, it's important just to kind of understand what the options are, and also to like understand like what you do today and how it can affect your tomorrow. Also, like all of these things, you have to ensure that you have your IP in order, because at some point when you do a price round, you're gonna be asked to make a representation that you own all your intellectual property. And at some point, maybe not the first price round, but maybe the second or third, people are gonna take a look and they're gonna actually check, and they're gonna do due diligence, the lawyers on the other side, to see that you have that intellectual property. Common startup things, yes. All of these are common, Avi, but I will also try to get to that. We only have 10 more minutes. I have 3 more things I want to chat about. I'm going to do them really quickly, and then I'm going to leave 5 minutes to talk about the other things. Okay. Too fast. Labor and employment. All I want to say about this one is, this one you have to just make sure you're doing this correctly. So when you're working with other people, you want to classify people correctly. Intern, independent contractor, employee, like a founder, whatever it is. This is one early way, and a founder is not a legal term in terms of employment. But the reason this is important to try to classify people correctly is because you want to make sure you have the right documents and you're limiting risk, and you're actually ensuring that you own all the equity you think that you have, and everyone's kind of good. So one of Avi's questions is like, hey, what's a common startup issue? Well, what you don't want to do is have a big team of people and none of them have real clear expectations of what they're doing. And there's a lot of emails where you're like, hey, why don't you be the chief marketing officer? And I'll give you like 5% of the company, and there's no documents, so there's no expectations. And then maybe at some point you're like, well, that person actually never showed up. And maybe you'd also say, actually, for that, I'm going to pay you a salary of $180,000 a year from what financing source, not sure. Once we get financing, and I'll just defer the salary until then. You've created a lot of problems in these emails that are expensive and annoying to unravel, some more expensive than others. If you create a wage and hour issue where you basically say, I'm going to pay you this and I don't pay you this, like that, you can be personally liable for. If you create something where you accidentally give away equity and it's not subject to a vesting schedule or anything, that can become a due diligence problem in the future, especially as you're trying to actually sell equity, because you will have to tell people, people will, like your investors will want to know with absolute certainty who all of the owners are and won't want ambiguity. If you do something like you miscategorize an employee as a contractor or a contractor as an employee, that can be more forgiving, but the IRS, especially with big organizations, will come in and heavily fine you if you do that. So it's just important. People, as you grow a business, you will find out people are like one of your single biggest areas of risk, also because they're just people. So you have to give some thought to that kind of generally. All right, we have contract and terms. This one and counsel, I'm going to go really quickly, and then I'm going to answer questions because I think it's more valuable. When it comes to your initial contracts, when you're starting up your business, you should have, if it's an online business, your online terms of use. If it's a service-based business, your service contract. Like, you should have your main contract that you start with. And then you should understand what your risk tolerances are and where your liability, like what liability you do want to take, what you don't want to take. And this is where it gets fun. This is where in my practice, I do the fractional general counsel stuff where every day we're just trying to make the operation better. We're trying to get you paid. So you have your contracts be more acceptable within the risk tolerances that you've set, and get to a liability perspective that allows you to feel like you're happy about it. I point that out because contracts are often like, that's where you eventually like get paid. And so you want to spend some time on that and understand, like, if you have your general contract up and going and ready, not everyone's going to take it depending on the type of your business. But I think it'll also help you sort of understand how that relationship works between your customers and such. Okay. Legal counsel. I always think it's weird. Like, that works better when there's like a screen or it's just me. It's like me and me. So with legal counsel, what I want to ensure you understand is that work with somebody who you're comfortable with, okay? Like, there are a lot of different lawyers in the world and a lot of different people in the world. And that means there's a lawyer for you. There's a lawyer who makes you feel comfortable and who answers your questions and gets to that level when and how you want it to be. So just like you don't want to have, like, lawyers are like doctors, you know, you don't want to have your pediatrician doing knee surgery. You want to be mindful of this. And this is also important because, like, for instance, I don't mean that like find a startup lawyer. Yeah, sure, to do the startup stuff. Yes, you do want to do that. But another answer is, like, when I'm running fractional general counsel services for my larger companies, I know when I'm not a knee surgeon. I know, okay, so if there's litigation, we're going to hire a litigator and we're going to talk about these different things. If we're going to deal with something like data privacy and protection, I may be able to implement and like deploy all of our policies and such, but I may not know these specific areas of expertise. So you're going to have to work with lots of different lawyers over like the season of your life. I don't think I think that's expected. Try to find somebody who you can ask questions to and you feel comfortable about with, blah, 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 who you feel comfortable with. Because if you don't feel comfortable with them, again, it's like they should be your advisor. You know, there are plenty of places to just find documents online. I don't think that's kind of necessarily what you're looking for. All right. How do you find the right legal counsel? It's so difficult to find one that meets your needs. Expectations. Any recommendations? Where should we look? Well, I mean, I think it really depends. So you should ask your friends and your colleagues. Like, sometimes when people send, I don't know what it is about me, like when people come my way and I'm not the person for them, which sometimes I am the person, I'm like, hey, I love connection. And then you'll know it. When you're not the person for them, I try to send them to another place. So if you can try, like if you're talking to someone and you're like, oh, you may or may not be the right person, try to see if they can send you to a different place. It's hard, Maya, to know without knowing more which place to send you to, because there are legal clinics. Legal clinics are really good resources. They generally tend to have defined periods of client selection and narrow scope, but they're really good at counseling, and they're really, really good in terms of sort of feeling like an intro level to a lawyer. Oftentimes they also have limited scope, but they'll help you kind of get to that next place. A big law firm can be a hard place to start unless you've got a lot of experience with lawyers, because there's the business model is sometimes challenging. And it's funny because like all of my students who end up in big law, a lot of the times I'll end up talking to people that don't make sense for them, because big law makes a lot of sense for like a Series B or a C financing. It may not make as much sense when you're trying to do, you know, something that's, you know, you're trying to get like some expectation and counseling on like initial stages of like, what does this mean for my business, or how to get my operational contracts going. So I would say ask people, do your research, talk to at least a couple, just see if you feel comfortable with them. Okay, Delaware Holding LLC. What? I guess I don't understand that question. Does anyone else have other questions that they want to ask? Should my LLC and website match, or can they be different? They can be different. That's preference. So the name of your business can be different than the name of your brand. It's really up to you. Some people like to have them the same, but they don't have to be. You do have to make sure when you're entering into contracts that you're doing it in the correct name, not your brand name, but your other name. If you do, for instance, have a brand name or a trademark that's different than your entity, and you want to go by that name, that's where you have to do a DBA, or doing business as, or assume business name. Is it more important to hire outside counsel or hire a general counsel? Antonio, normally hiring a general counsel for a startup is you don't have enough legal work to keep a person busy. So in fact, I actually work with a lot of companies and growth stage businesses where I am their general counsel office, me and then like my staff of lawyers. And the reason for that is because they have enough work that like they've started in one of these other levels and they need help. But to have an in-house legal person, you need to generally be of a certain size. And so I think if it's your startup, I wouldn't probably start with that. But you do want to work with somebody who can help you kind of get to all these different steps so you're not constantly working with different lawyers. Let's see, hold on. Would I not, what's the question? What do I normally advise as a safe note? I'm not sure I understand the scope of that question. Do you mean like post-money or pre-money? Is it normal to pay legal counsel with common stock? I don't like, you can. There are ways you can pay an attorney with equity, and there are ABA guidelines around that. Most of the time, the lawyers that I know who now take equity, generally like they invest separately. So I'll see them say like, here's the cost, and you'll pay them, and then they'll take that money and they'll invest in you. I think you have to be cautious about the conflict of interest. So your lawyer is your lawyer, not your investor. And I think it's helpful for your lawyer to like put down cash on you if they believe in you. And I definitely would do that. But I want to make sure that you understand that like you don't want to play both sides. So having your lawyer who's like, let's say, writing your bespoke operating agreement and also investing in you, that can cause some conflict issues. Do I have a template of the safe that I advise? I mean, the one online for Y Combinator is the one that you would use. They're generally not adapted. The question you have to answer is whether you do a safe that is pre-money or post-money. And unfortunately, I don't think I'm gonna be able to talk about that in the zero time we have. Martin asks, is the legal clinic a good place to get a terms of use and a privacy policy? Yes, it is, Martin. That's a perfect example of what a legal clinic does a really good job of. All right. So I think we're at 1 o'clock. Lucas, do we have a hard stop at 1?
We could probably go over maybe 5 minutes or so if there's still questions.
Okay, because I started getting like frantic in terms of the like, am I answering the question? No, what, you know, is the all right. I'm gonna put, even though I'm bashful because my picture's there, that phone number is not good because I'm not going to the office so much because COVID. But that email is fine, or hharper@kentlaw.iit.edu is fine. If you, and Lucas like can send you, I think you have my Harper legal tag stuff, can send whoever wants to some contact information if you'd like to schedule a meeting. I have office hours at Polsky Monthly. I'm happy to talk to anyone about that. In the meantime, does anyone have other questions? Like the chat's been moving quick. I've been trying to follow it. I'd say I'm doing a solid B+, but that's, you know, maybe not great. All right. All right. We got McDowell's, we have trade secrets. I'm up too far. All right, we got people saying thanks. Does anyone else have a question?
I see one question, and it's, are there any downsides
Yes.
to using your home address for your business address?
Oh God, I didn't even see that one. Thank you. Well, it depends. So I once represented a diamond dealer and he was like, I don't want to use my home address. Okay, fair, good point. So like there may be issues. Like the thing you have to realize is when you use whatever address you use for your business is open for everybody to see at the Secretary of State's website. Now, I don't know if that matters for so many people, because also like you could probably just Google me and find out, like I'm not super secretive in any of these things, but like obviously some people have different sensitivities to that. So maybe in terms of your actual, your other business, let's say you have a restaurant. If you have a restaurant, you actually are going to get your business license in the city of Chicago based upon the principal place of business that you list in your organizational documents or in your authority to do business if you're not a Illinois company. So if you put your home address and you're opening a restaurant, you can't open a restaurant at a home address. But like these are some sort of subtle things. If you wanted, there are a lot of, the Secretary of State will send mail to your registered agent address. It's important that you get that mail, that it's not like an outdated mailbox or anything, because otherwise you're often going to miss, if they get sued, they're going to send you that. Or if you have an annual report, they're going to send you it to your registered agent. If you miss it, you may go out of good standing. How often do utility patents that significantly improve a process method get licensed to companies? Can a utility patent integrate other patented technology embedded in it? How often do they get licensed? Because I don't know how to answer that question. I mean, there certainly are. Let's say that you created, and if you want to go on mute and explain more, I can certainly tell you that. But like, let's say that you created like a medical device and you're just an inventor, you're not like in the process of making that. You could potentially license that to like a medical device company. But I've found that in working with a lot of startups, it's difficult to find the right person to license that to. So like, while it's very easy and well, it's very possible, I do think it's like, you know, a lot of companies will have R&D departments, and so they may not be. So from a commercial perspective, I'd say, I don't really know. From a startup, my experience, I'd say it's difficult to find your way to network into that. Can a utility patent integrate other patented technologies embedded inside of it? Well, you would generally have I'm not a patent lawyer, right? But yes, of course you can add on to them. That would generally be prior art. So, and I think this is where you'd want to ask a patent lawyer about whether there would be a difference between a patent lawyer or a patent that like extends the current patent and builds on it, or like a new and separate one. Resources. Okay, so, and Lucas, if you remind me, I will send you, I can't guarantee it's going to be today, but it'll be by the end of the week. I will send you, there are a couple of like really awesome, super silly books on Amazon. They're like $2 on Kindle each, and it's like sort of valuation, sort of this. I like them a lot and I suggest them. I think they're really good. Also, a lot of you are asking about legal clinics. I'll send you some very common legal clinics in the city. So yeah, and somebody did point out, there's an innovation clinic. Emily Underwood runs that. She's awesome. The University of Chicago also has the IJ clinic, which is the Institute for Justice. Beth Krieger runs that. That one has different admission requirements. So generally they want you to, like, it's not as broad as the innovation clinic, but that's another one. I have a clinic at Chicago-Kent, IIT Chicago-Kent. This one's branded as the Startup Legal Shop. Northwestern has a clinic, Loyola has a clinic, John Marshall has a clinic. And so a lot of them are available. And sometimes, you know, oftentimes like we're a pretty tight knit group. So if we can't help you, we generally send you somebody else who does. And if, yeah, and there are also a lot of startup lawyers out there too. So there's a lot of good resources in the city. Okay, it's 1:05. I have talked at warp speed for an hour. I hope this has been helpful to everybody. Okay, Chad gave me a thumbs up. Thank you, Chad. It was like, Michael gave me a thumbs up. I don't know why, like I can't see all of you. And I gotta tell you, like I'm managing different screens here, but I just wanted to say thank you so much. It's always really fun to hang out and to hear about you guys. I do miss seeing your faces. I miss all of you, and I I really do hope that we get to meet in real life soon, if I've not already met you. And in the meantime, I'm around Polsky. Let me know how I can help.
And I just wanted to say thank you to Heather as well for being with us today. We really appreciate it. I'm sure it was incredibly helpful, and I will be sure to distribute any links you might want to share with the group in a follow-up email if I touch base with you afterwards. So thank you very much.
Happy to do it. Thanks, guys. Bye.
Thank you.
Thank you.
Thank you.